Good evening, everyone, and welcome to the Banco Court. I'd like to start by acknowledging the first owners of the land and waters across the state of Queensland, and in particular here in Brisbane, the Turrbal people and the Yuggera people. I pay my respects to their ancestors and their elders for their patience, their courage, their wisdom and leadership in looking after the land and waters in the past and today. Before we go any further, I'd like to invite Uncle Chegg to welcome us to country.
Thank you for that wonderful welcome. So, my name is Gregory Eggett, but as I'm known in the Aboriginal and Torres Strait Islander community of South East Queensland, Chegg or Uncle Chegg. Simply put, I'm just a black fella from South East Queensland. But my mobs are Gurrumpul, Yuggera and Kawi, which, as you all know, gives me links to just about every part of South East Queensland. And of course, when I got the invitation to, first of all, an invitation to come to be a part and for this wonderful oration, the Mullenjaiwakka oration, and I thought, yes, I'll jump at that. But I didn't read the little fine print down the bottom was, Uncle Chegg, can you do the welcome if you want to? And I thought, yes, of course I will. Yes, Wyatt, of course I will. Because, first of all, I just want to pay and acknowledge all the Aboriginal and Torres Strait Islander people who are in this room and their descendants, like the descendants of this land here. We don't be in this room, we don't stand here like I am today without the struggle, the perseverance of our elders that have gone before us. And when I talk about elders, I talk about elders not just in the 20th century, I talk about the elders who were there in the battle when colonisation was here 200 odd years ago. They're the people that I talk about as the people that has made this struggle and made us who we are today and gives us the privilege to do stuff like we are doing here. So yes, I just wanted to do that because, you know, we are the descendants of the oldest living continuous race on this planet. And I think sometimes people forget about that. And of course, as the oldest continuous living race on this planet, are we recognised in this country like every other country recognises their First Nations people? No, we're not. But hopefully that's going to come in the future. But getting back to this oration and this narrative and this story that Tony is going to talk about tonight, is that, look, I grew up in the best part of South East Queensland, which is Inala. So did Mr. McAvoy. And so did Auntie Vi and Uncle Clive McDermott. They lived 2 streets away from me when I grew up in Inala. So I jumped at the chance to come along and to be a part of this because as a little boy in Inala, my father, whose name was Clive, but he was a non-Indigenous person, he used to work with Uncle Clive. And so, as little people, we heard the stories about their deadly son and about all the accomplishments that he did in the early days. So I knew of Mullenjaiwakka back then. I knew of him. I didn't have a chance to actually meet him. But look, I think it's only fitting that this room is packed for such an important oration tonight. I won't talk too much more because I'm waiting to hear my brother boy here, Mr. McAvoy, and what he's got to say. So, yep, thank you. And I'll just say 2 words in language because I'm not a language person, but which is Bolka Bolka, which means welcome, welcome, and welcome to Yagara and Turrbal country. Thank you.
Thank you very much, Uncle Chegg. It's a great pleasure and a privilege for me to welcome everybody here to the Banco Court tonight. I acknowledge my judicial colleagues in the room, members of the legal profession, members of the public, and most importantly, the family and friends of Mullenjaiwakka, in particular, his daughter, Philippa McDermott, who has travelled to be with us tonight and who, on behalf of the McDermott family, permitted the Indigenous Lawyers Association of Queensland to name this oration in her father's honour. It is absolutely wonderful to see the turnout in the Banco Court tonight, which is a reflection of the importance of Mullenjaiwakka in not only our legal history, but in our state's history. And it's also a reflection of the hard work and dedication of the Indigenous Lawyers Association of Queensland and the time and effort that they've put into this. But importantly, a credit to all of you for joining us tonight. I know that our esteemed speaker, Tony McAvoy, is going to have quite a bit to say to us about Mullenjaiwakka himself, so I won't go into too much detail about that now. But at its heart, the Mullenjaiwakka Lloyd McDermott oration has 3 goals. The first is to increase dialogue and raise awareness of current legal issues affecting First Nations peoples by providing a platform for leading First Nations voices in the law to educate the Queensland legal community. The second is to encourage appreciation and respect for the achievements of First Nations people in the law, including increasing the recognition of First Nations lawyers and the Indigenous Lawyers Association of Queensland. And the third is to establish a conversation amongst the Queensland legal community around law reform, including encouraging recognition of the enduring nature of First Nations law in light of the Uluru Statement from the Heart's call for substantial constitutional change and structural reform. Now, many of you would be aware, or if you are not, I think you will walk away from tonight being very well aware of an important trust named in honour of Mullenjaiwakka. It was established and launched at the Bar Association's annual conference in March 2009. The Mullenjaiwakka Trust was established for the relief of Indigenous persons in Australia for whom coming to the Queensland Bar is a primary career objective and who have suffered some socio-economic disadvantage which may constitute an impediment to their pursuit of a career at the bar. The Bar Association, through that trust, offers applicants the ability to apply for financial assistance to cover their expenses which may be incurred in pursuing a career at the Queensland Bar. So I want to take this opportunity to encourage all of you in this room who might be watching and to convey that encouragement to your friends and family and colleagues to not just consider contributing to the trust, but to do it, to contribute to the trust, because it is such an important and essential part of, again, not only our legal community, but the whole of our community, to increase the diversity of people who are coming to the bar, practicing as barristers, remaining at the bar, and therefore likely future judicial officers. Not just diversity in general, but given the history of our nation, First Nations lawyers are to be encouraged significantly to come to the bar, remain at the bar. And any assistance that the whole of our community can provide in that endeavour must be encouraged. The organisers of the oration have asked me to particularly thank His Honour Judge Nathan Jarrow, John Fraser and Mullenjaiwakka's family for their help in bringing this oration to fruition. Before I introduce our speaker, I'm going to invite Philippa McDermott to come forward and say a few words.
Wow, this is an intimidating place to stand. I've only been in a court a couple of times, so this is really a thrill and an honour, of course, for me and our family. Good evening, everyone, and thank you, Uncle, for that beautiful and warm welcome. Inala seems to have produced a lot of pretty amazing people, and many of whom are in this room, and of course Macca as well. Tony. I too, of course, would like to acknowledge the Yagara and Turrbal people, their elders past and present, emerging leaders of the future, and many of which, of course, are here in this room. I also acknowledge all the Indigenous people in the room tonight, and your cultural connections and authority to your land, sky and sea. And in further keeping with the NAIDOC theme of this year and Uncle Claire Chegg's sentiments, the theme for this year is for our elders, and I extend that acknowledgement to all of your elders, Indigenous and non-Indigenous, and I acknowledge them as well, of course, for all they've done for us here in this room with such privilege we have, including my own privilege. They paved the way for us, and none of us would be here if it wasn't for our elders. Brisbane's like a second home for me, and of course our Mullenjaiwakka country, my grandfather's country, is just down the road. I've spent most of my life coming here, between here and the Tweed, and with Dad, and staying with my grandma Vi in Inala, or Auntie Vi, the Queen of Inala, as we used to call her, or she's better known. My grandmother was a big presence for those of you who knew her, and she could hold court with the best of them, and she usually did. She is a proud Waka Waka woman, born on Eidsvold Station in 1917. She lived a healthy life for 96 years and passed away at 98. And she was a determined woman who believed in church, education, and our people. Vi could get you to do just about anything for her or the mob, and always with a smile and a laugh. And I suppose that's where Dad got his drive and his joie de vivre. Dad lived his life to the fullest and had a great time doing it. There is a saying that no one had a better time than Mullenjaiwakka. He was a truth teller and a truth seeker, a lawyer, a jazz guitarist, a sportsman, an academic and an activist. But he had his demons too, like we all do, but he never judged. He understood our human frailty and the struggles that people had to endure, because he had many of his own. In our family, education is everything, and our saying is they can try and take your land away, but they can never take your education away. Once it's in here, it's in here. And that's why the Mullenjaiwakka Trust is so important, and so important was to him and our family and our mob. It's to help our mob through what is a really tough and very expensive process to get into the law. So I'd really like to encourage you all, like our Chief Justice here, to dig deep and to help donate to the trust if you can. You know, it will make a difference in real people's lives, not only our people who are entering the law and what they might achieve, but the people that they're going to represent as well. Just look what Lloyd achieved. He was given an opportunity to go to a great school, and look what happened. Dad and I often used to talk about what Australia would be like if more of our people got an opportunity like that, and it would be a very different place. So dig deep if you can. I must say, he would also be so proud of the number of our mob practicing, and especially in Queensland. You guys are smashing it up here. So many of you are in the room tonight. Thank you for all of your kindness and remembering Dad and this wonderful legacy. I'd like to acknowledge the trust and all the members who continue working and supporting young Indigenous lawyers. Thank you to the Queensland Bar for naming this after him. He was thrilled and proud. I've just got to say thank you to a few other people. Thank you to Wyatt, Zach Fraser and John Fraser, who approached me and the family for permission to name this oration after Dad. How could I say no to that? I'd also like to acknowledge, of course, the Chief Justice here of Queensland, and thank you for your support and all of you here tonight. And last but not least, our dear and deadly brother, Tony McAvoy. Tony and I, or Macca as we call him, have been firm friends for a long time, 25 years or more, and he was a great friend to Dad as well. I know Tony's always up for a challenge, because back in the 90s when I was at Koori Radio doing a show on Saturday mornings, I suddenly got sick one Saturday and had to find a replacement at very short notice, like 6 a.m. in the morning for a 10 a.m. start. I rang Tony, panicked, and asked, well, begged, really, if he could cover me. And I said, "It's really easy, brother. Don't worry. All you have to do is play a few tunes, have a yarn, and tell them the time. It's live radio, no pressure, and it'll all be over before you know it. You'll have someone to help you panel there. It'll all be good." And Tony kind of reluctant, and I was like desperate, and he reluctantly agreed. And 2 hours later, there he was in front of a live microphone. And off he went. I can't remember if the panel operator stayed. I don't think she did for the whole show and left him and his mate on his own. But I think she stormed out, actually. But and the panelling is the hardest part of that job. But he smashed through it and did a hilarious job. I was listening from my sick bed, and it was hilarious, with all the mistakes on the buttons and the panels, and everything going wrong. But they made the most of it. And we had a huge laugh, and then it actually became a regular show, aptly named The Mystery Show, because you never knew what you were going to get. So he's pretty good on his feet, and live radio probably helped you do that, Tony, I'm sure. Of course, he's taken up a lot more serious challenges since then and continues to shine for us, and we couldn't be more proud of him. He's funny, he's feisty, he's fierce, but he's also friendly and humble. He was great brothers to Dad, and I couldn't think of anyone more fitting to be the keynote speaker tonight for the inaugural Mullenjaiwakka Oration. Thank you. Thank you.
Well, I think it's hard to outdo that introduction of our speaker, Tony McAvoy. I did want to say, Philip has started by describing this as an intimidating space, and perhaps a court is, but I often feel when I'm in this room for other types of events like this one, that with this beautiful Sally Gabori painting looking down on us, and with the warmth and heart and soul that painting brings to the room, it's really the opposite of intimidating. It brings us all together on occasions like this, which is a wonderful feeling. I'm very pleased to introduce the keynote speaker tonight for the first of the Mullenjaiwakka Lloyd McDermott orations. As we've heard, there was a sliding door moment in the past. We may never have had Tony McAvoy, the barrister. He may have become a famous radio announcer or presenter. But radio's loss is our gain. And Tony has been a barrister of some 23 years experience, 8 of those as senior counsel. There is more detail set out about Tony in the program, but it is very fitting that he presents this inaugural oration because just as Mullenjaiwakka was the first Indigenous barrister in Australia, Tony was the first Indigenous person to be appointed senior counsel in Australia when that happened in 2015. We are honoured indeed to have a person of Tony's calibre and experience with us to present this oration. Before I ask you all to join me in welcoming him, I've apologised to Tony and to Philippa, and I'm now apologising to all of you. I may have to sneak out at 7:15 because I have something I can't escape, and I'm just apologising so nobody thinks I'm being rude later on. But would you now please all join me in welcoming Tony McAvoy.
Thank you, Chief Justice. Thank you, Brother Chegg, for the warm welcome. I too acknowledge the Yuggera people, the Yuggera people, Turrbal, and all the other mobs around this area, the Ginniburra, the Yuggum Bear, the Kombermeri, the Noonuckle, the Noogie, Cubby Cubby. They may sound like just names, but I know people from all of those mobs. They are my friends and they are my brothers and sisters. I want to say thank you to you all for coming tonight. It's wonderful to see so many of my legal brothers and sisters here. I didn't think that Justice Crowley would make it. I know he was in Sydney today, and I'm flattered that he made it back tonight. It's also a wonderful pleasure to see my legal brother, Judge Nathan Jarrah. To all the Aboriginal and Torres Strait Island people, all the First Nations people here, I acknowledge you all and thank you for coming out tonight. I also acknowledge all of the judges and justices of the various courts in Queensland that have come out tonight, and am a little overwhelmed at the response tonight. This year has been one full of challenges. In the last 6 weeks, I think this is my 5th keynote or oration. I delivered the Austin Ash oration in Darwin about 3 weeks ago, and Austin Ash was a Chief Justice of the Northern Territory Supreme Court and had been an administrator there. And I delivered 2 weeks ago, I think, the Marla Perlman oration, and Marla Perlman was the Chief Judge of the Land and Environment Court in New South Wales, and I knew Marla. But I didn't know her in the way that I know Mullenjaiwakka, Lloyd. And so in thinking about how I might approach this particular oration, having done so many, I decided rather than to engage in some perhaps esoteric legal discussion about a topic that was of my own particular interest, as I have done in other orations, I decided I would really try and talk about Mullenjaiwakka the man, because there are many insights that we can all draw from Mullenjaiwakka. And some of what I have to say is in the brochure, and some of what I have to say has been said in one way or another by Philippa. But there is there is much that I can say about this man because I knew him well. So it is an incredible honour to have been asked to deliver this inaugural oration in memory of the legend that is Mullenjaiwakka. He was my friend, he was my mentor, and he was a role model. With Philippa and Gabriella and Tom Evans, we delivered a 4-part eulogy at his funeral. He is a person that was incredibly generous to me, and in a way that it's hard to describe, he has shaped my career, I believe. He was many things. He was a Waka Waka man through his mother, as Philippa has said, Auntie Violet, and through his father, a Mullenjaiwakka man, through Clive Dermott. There's a park in Inala called Clive Dermott Park. Chegg and I were just talking about that park a few minutes ago. He was a Wallaby. He was Australia's first First Nations barrister. He was a scientist. He had 4 degrees, university degrees. He was a jazz guitarist. And to my mind, most importantly, he was a man of principle. He loved life and he loved his people, our people. He was gregarious and he was a great storyteller, a raconteur of the type that we rarely see anymore, I think. Not only could he hold court with hilarious vignettes and some longer stories, he revelled in it. He was at his peak Lloyd when he was in his storytelling mode. But I have to say, although it might not fit neatly with the notion of the consummate performer that he was also a very humble man. And the truth of the matter is that he didn't seek out the limelight. Indeed, one of his colleagues in Chambers told me that they'd been in Chambers for over a decade together and he never knew that he'd played rugby union for Australia. And it was only during conversation one night that he found out. Nobody on the floor knew. He didn't make a big deal of it. He let it slip one night and there you go. The trait that I thought really separated Mullenjaiwakka from the rest of us, mere mortals, was his panache. He had great style and he always used to appear to have taken everything in his stride. He was like some of those truly great sports people who always seem to have time on their side. I've seen him in action many times and it was a beautiful thing to behold. As has been said, and you can read in the brochure, he was born in 1939 in Eidsvold, and he was basically living in a tent when he went to Churchie here in Brisbane. The public record tells that he went to Churchie on an academic and sports scholarship, but part of the truth of his history, and I didn't know this until one of his family spoke about it at his funeral, that his extended family would put in money every week. They were farm labourers and they would put in money to pay his school fees, to keep him at school. He was the only one that they could do that for, and they sent him off to do that. I'm reminded by Philippa that Mullenjaiwakka held the Queensland state record when he was at school for the 100-yard sprint. He held that record for more than 10 years, and he was apt to tell you, if you would listen, that he had to run twice as fast as everybody else just to be equal. At the age of 22, while studying law at Queensland University, he was selected for the Wallabies. He had played 10 games for Queensland at that stage. and he played 2 Test matches against the All Blacks. But by the age of 23, he had already been unceremoniously dumped because he would not consent to travelling on a wallaby tour of South Africa as an honorary white, the only way the apartheid South African regime would allow him to play. Mullenjaiwakka then changed to rugby league for a couple of years. Played 2 seasons with Wynnum Manly with his good friend Lionel Morgan, who at that stage had played rugby league for Australia, and so they were a pretty devastating wing pair for the Wynnum Manly Seagulls. And I over the years have done a lot of work with the mob from Dunwich, and I would often run into Lionel, and he would pass a message for me to deliver to Mullenjaiwakka, and I would get another message from Mullenjaiwakka to pass back to Lionel when I saw him next, and they kept contact with each other. After Mullenjaiwakka graduated from law school, he worked at the Commonwealth Deputy Crown Solicitor's Office in Canberra until he was called to the New South Wales Bar in 1972, is my recollection, though it doesn't say that in the brochure. But I remember an event in Sydney in 2012, sorry, and at that stage it was the 50th anniversary since Lloyd had been called up as a wallaby, and the 40th anniversary since his call to the bar. And I made the observation at that point that it was probably an event that we'd never see again. That combination of the time served at the bar and playing rugby union for Australia probably is not likely to arise. The next First Nations barrister was Pat O'Shane, and she was admitted to the New South Wales Bar in 1976. I know Pat very well, as well. And she was followed by Bob Belair in 1979. And then, for those of you who are interested in such things, I think the next was Mick Dodson, who went to the Victorian Bar in 1981. Practising at the New South Wales Bar, Mullenjaiwakka was fond of telling me, I don't know how many dozens of times he told me about the fact that he used to get briefs from the St Mary's Aboriginal Legal Service, and that occasionally he got paid. In the wake of the Royal Commission into Aboriginal and Torres Strait Island Deaths in Custody report in 1991, the New South Wales Government established an Aboriginal Justice Advisory Committee, and Mullenjaiwakka was the chair of that committee, the New South Wales AJAC as it was known. He was practising at the bar and chairing that committee, and he was still chairing it when I arrived in Sydney from Brisbane in 1994. I'd met him before that at the... I should not... No, I won't. I'd met him before, and so it wasn't the first time I met him, but we got to know each other very well. When I started in Sydney, it was at the Department of Aboriginal Affairs, and Philippa was already working there, and we became great friends, and I got to see Lloyd very often. I was also a director on the Lloyd McDermott Rugby Development Team, for which Lloyd was the namesake and patron, and through that organisation I got to see a number of young men and women change their life's course through access to rugby union as a vehicle for change, but also through the insights that they obtained from travel overseas and seeing different ways of life, which is something that they probably would never have been able to do from their local community circumstances. And we were all DJs on the fledgling Koori radio. I was a DJ as a result of Philippa's no-show, and Lloyd had the best jazz radio program in Sydney. I have no doubt about that. And he spoke about all of the jazz musicians as if they were sitting there in front of him talking to him. He knew who was playing which instrument on which song, and just such a deep love of jazz. I also remember being with Mullenjaiwakka at a party in 1996, following Bob Bellaire's appointment as a judge of the District Court in New South Wales. He was the first First Nations judge in Australia, and I remember the party well to a certain point. But Bob and Mullenjaiwakka were truly legal brothers in arms. They had a great respect and love for each other, and they were a fantastic team. And it was great to be in their company. I didn't sit the bar exam in New South Wales until 1999, and before doing so, I went and saw Mullenjaiwakka for his advice, and I also saw Bob Belair. He wasn't then a judge. He was at the Public Defender's Office. Mullenjaiwakka was very supportive, and while I had my doubts as to whether I could make it, as we all do when we embark on these things, Mullenjaiwakka had no doubt at all. He said, "Of course you can. What are you talking about? Go ahead and do it." Whereas Bob was a little bit more circumspect and gave me some advice on how Aboriginal lawyers might be perceived by the profession and the public. Then from the moment I was admitted, Mullenjaiwakka was my greatest supporter. He introduced me to anybody and everybody he could in the profession, and he knew a lot of people. He brought me on as a junior in a couple of matters in my first year, I think, and then he talked about how good I was to anybody that would listen, just from that one or two matters where I was his junior. He was the person that I turned to when I needed answers to questions that I was too embarrassed to ask anybody else. And mostly I got answers from him over the phone, but occasionally I would have to track him down at one of his haunts, where he would be hanging out for the afternoon, where he would tell the story again of how well I had juniored for him and how I was a young barrister going places. As my career continued, he was always in my corner. In 2011, so I was at the bar 11 years, 2011, there was an interview that he did in a national newspaper. And in the course of that interview, he named me. He said, "And Tony McAvoy is going to be the first Aboriginal silk in Australia." And I was embarrassed and a little bit chuffed, but I was embarrassed. It was way too early for me to be thinking about that. I hadn't thought about it, but he was calling it out. But it wasn't just my career he was interested in, although he kind of felt that way from time to time. It wasn't. He was always asking about the other up-and-coming barristers, such as Judge Nathan Jarrow, and Justice Lincoln Crowley, and Magistrate James Morton, who was here. He always spoke highly of them all, and he always encouraged them to do their best. He talked about all of our deadly solicitors in New South Wales as well. There are many: Terry Jenke, Jason Barrett, Damien Barnes, Carrie Nichol. For those of you who practice in New South Wales, you'll be familiar with those names. Fantastic lawyers. Although by the sort of later part of my career, I developed my own sense of the importance of a culturally safe environment for our law students and young lawyers. This was something I developed from my time as a clerk and solicitor here in Brisbane in the firm of Paul Richards and Associates, with the likes of Justice Darryl Rangier and the recently appointed National Native Title Tribunal President Kevin Smith. We were all clerks together here in Paul's office, and whilst we didn't fit in anywhere else, we were safe and looked after each other when we were in Paul's office in George Street. So I had an understanding about that, and I took steps to, with Lloyd's blessing, to set up a national Indigenous legal conference in 2006, and that conference is still going. I had a hiatus over the COVID period, but it's back on this year in Sydney as a place where young Indigenous lawyers could meet all of their cohort. And I tried to attend every conference and say to them, look at these people around you. They are the people that will go with you through your career. They are the people who will be your cohort. And as you get better and more senior, you'll see them rising too. But it was Mullenjaiwakka who showed me, I think, what it means to be a senior Aboriginal lawyer who leads and cares for those coming behind. He did it with ease, and he did it with genuine affection. And I think I soaked some of that. I hope I soaked some of that up by osmosis. It's not something he ever talked about, but I watched it on many occasions with many of the young lawyers, some of whom are here tonight. We spent a good deal of time, Lloyd and I, speaking about politics. He was very well read, and he was very well informed on the life of many of our political heroes. He knew the life and work of Nelson Mandela intimately. He talked about the black American footballer, singer and civil rights hero Paul Robeson as if he knew him like a brother. And we talked about many things, but one of the things that we talked about is why it has been the case that there are so many successful First Nations practicing lawyers that have come out of Queensland. I think, I could be wrong, but I think that the Queensland contingent of more senior practicing lawyers who have successfully established themselves probably outnumbers the rest of the country combined. I believe I have a reasonably good gauge on those numbers. The answer to the question as to why so many have come out of Queensland is probably something best left to some PhD student. But my recollection is during our discussions, we reached agreement to the effect that there were fires of resistance which kept burning through the segregation period when our parents and grandparents were locked up in the mission days. And those fires had fuel poured on them during the Bowker-Peterson years in the state. And it put us in a position where we just had to engage. We had to engage in the law if we wanted something to change. He loved his jazz music. He took jazz guitar lessons well into his 70s. And maybe after the love of Philippa and his granddaughter Eva and their family, jazz music gave him the next most joy in his life. He saw many jazz musicians live, and he and Philippa, I think, travelled to New York to see some. But somewhere close in that mix may not have been something that took pride of place over his love for jazz or his family, but somewhere close in there, particularly in his later years, was the pride he felt in the young lawyers coming through and the assistance that he was able to give as a mentor and as a trustee, both on the New South Wales Indigenous Barristers Trust, as the patron of the Lloyd McDermott Rugby Development Foundation, and this Mullenjaiwakka Trust. My recollection is that he was contacted by John Fraser of the Queensland Bar to let him know that they wanted to set up the trust in his name in his home state. And I remember him telling me about it several times and how proud he was. Really deeply proud. He spoke of it many times. He mentioned the trust often and told me about the events that he was travelling to help to promote the trust. But I must say here that the pace of change in the legal profession has been slow. We are fast approaching the 200th anniversary of the Supreme Court of New South Wales, the first Superior Court in the Australian colonies. And yet there's probably less than a dozen practising barristers nationally. And only Justice Crowley of this court and myself have taken silk. There are only 3 practising female barristers in the country of which I'm aware. Evelina Taraga, Melia Ben of this bar, and Jacqueline Turfrey of the Victorian bar. There are only 2 district court judges nationally, Judge Nathan Jarrow and Judge David McLean in WA, with Judge Matt Myers sitting on the Federal Circuit Court and another intermediate court. And until last week, there were only 2 Supreme Court justices, Justice Crowley, who was the first, and Justice Michael Lundberg of the WA Supreme Court. But of course, last week we saw the elevation of Justice Louise Taylor to the Supreme Court of the ACT, and we are still celebrating that excellent appointment. For years, the bar associations on the East Coast have been focusing on increasing the numbers of practising barristers. I have been intimately involved in that from the New South Wales bar perspective, but I understand what's been happening here and also at the Vic bar. The reasons that we have focused on trying to increase the number of Indigenous barristers might be obvious, but I think probably warrant restating in this audience. The system needs diversity, particularly in relation to those communities that appear regularly. The quality of justice is improved in individual cases where parties can see the person vested with judicial decision-making power has a deeper understanding of the culture and norms at play. It may sound trite, but perhaps most importantly, the culture of the judicial institution, and then by extension the profession, I think is exposed to and perhaps confronted by different worldviews, including those of its first peoples. On this note, it has been my experience that it's not uncommon in major cities to meet somebody who has never had a social conversation with a First Nations person. It happens to me regularly in Sydney and in Victoria, let alone anyone that's been to the house of a Murray as a guest. Unfortunately, this is also the case for many in the legal profession and on the benches. On this point, I have had some discussion with some of my Maori colleagues, and was once asked a question by one Maori judge whether I knew why there were no Maori silks. Given the person asking the question was a judge, I put 2 and 2 together and realised it was because they are appointed to the benches as soon as they can be. So it is, for example, Justice Joseph Williams of the New Zealand Supreme Court, the equivalent of our High Court, never took silk. The theory was explained to me as to why they went to the bench as soon as they could was that, put politely, I suppose, that they seek to help the court become more bicultural by their presence and participation in the judiciary. The result of that strategy having been applied over a couple of decades now, is that more than 10% of the judicial officers in Aotearoa are Maori. 10%. And one must wonder whether the decisions in the truly groundbreaking cases such as Wakatu and the Ellis decision, and I encourage all the law students to go and look those up, are indirectly, or perhaps even more directly, a result of that strategy to immerse the benches in Māori culture. On this point, I cannot help but think about the closing session at the Australasian Institute of Judicial Administration Youth Justice Conference in Sydney in October 2022. As one of the organisers, I took it upon myself to ask the Chief Judge of the District Court of New Zealand, Judge Himi Tomanu, if the delegation from Aotearoa that he had led to the conference of some 20-odd people could give an impromptu performance of a song at the end of the conference. I know that they're fantastic singers, and so he called all the New Zealand delegates, Māori and Pākehā, judges, lawyers, departmental officers. He called them all onto the stage. And he picked a song about a sacred canoe voyage. And he counted them in, and they all sang the song in Māori, in tune, and with some harmonies. It was extraordinary. Very powerful moment. And as I understood it, was one of many songs that he could have chosen that they all would have been able to sing. So, standing here today, I wonder if I called all the judges up here, how many would be able to sing with me the Kabi Kabi and Bachelor song, Garinanami? How many could do that? Everybody, all the Murrays in southeast Queensland know that song. It's got an easy dance. We've got a few minutes, Chief. There are no statistics that I've been able to locate that would support the proposition that increased numbers of First Nations judges in mainstream courts reduces the rates of over-incarceration. I can't say that. I've looked. We looked in 2016, 2017, when I was co-senior counsel on the Don Dale Royal Commission. We looked just earlier this year when I was on the York Justice Commission truth-telling process in Victoria as co-senior counsel. I couldn't find it. But it's my view that the culture and character of our justice institutions must change to better understand and apply, where possible, the concepts of First Nations law. It must change to incorporate the procedures which ensure justice is properly dispensed in a land where there are pre-existing and continuing legal systems. And the decision in Ellis from New Zealand shows a pathway to do that, potentially. The institutions themselves, the justice institutions, must change. While there are no statistics about First Nations judges in mainstream courts, there are statistics which show clearly that there is a reduction in recidivism as a result of First Nations people being dealt with in specialist First Nations courts like the Murray Court here and the Koori Court in New South Wales and Victoria. But that's a long topic, and perhaps I'll have to deal with that elsewhere. But before I leave this subject, I want to add that in the life of a busy single First Nations judge, as they are sprinkled throughout the various benches, it is hard to imagine that any one of them, being a single judge on a court, could drive the institutional cultural change that is necessary on their own. It's too much to ask of them. They have to be given the room to be good judges, and it's only when we see the numbers increase as they have in New Zealand that we will see the cultural change that's necessary. The institutions themselves must take responsibility for the change that needs to happen. Since that discussion with my Māori colleague, that strategy has continued to resonate with me. I've discussed it with many other First Nations lawyers because we have this problem. We've been investing time and energy in trying to bring as many people to the bar as we can. And in New South Wales, I think there are 5 First Nations barristers, and I think there were 5 in 2003 when Lincoln and I were very junior barristers. So we haven't been as successful as we ought to be in attracting people to the bar. So my view is we've got to start thinking about it differently. And rather than the objective being to bring people to the bar, perhaps the objective needs to be to create potential future judges. And this seems to me to be where there might be some disjunct. If we accept that First Nations culture and life experience is a desired trait for judges in this country, and we acknowledge that there's gross underrepresentation, then perhaps it's time to rethink the criteria for appointments. We ought to have criteria for appointments that reflect those circumstances, I believe, if they do not already exist, because what we are doing now is taking too long. It would be remiss of me, I think, not to say something about the era that I sort of fell into, but Mullenjaiwakka was very much a part of. For the period that followed the 1967 referendum and the passage of the Racial Discrimination Act in 1975, pretty much through to the present day, those of us who are involved in the law and in government were engaged in a process which we understood to be about seeking incremental change, about bringing change step by step, taking the gains on offer and then moving forward to the next step. We pursued that change. The Aboriginal and Torres Strait Island Commission was created in 1989 and abolished in 2006, but it sought incremental change. And it's also true to say, and perhaps obvious, that since the time of ATSIC, there have been periods of very antagonistic government policies which have slowed our progress and caused us to take backward steps. My sense of our collective position over the last 30 to 40 years is that for those of us who have been able to create or reach an existence based on good education and with a good income, there has been some vast improvement. My life is something that my father could never have imagined. But for the vast majority of us, for our families, particularly those family and mobs that live on First Nations communities, our quality of life is going backwards. More people are suffering from mental health and drug and alcohol problems. More people are dying of preventable diseases. There is more domestic violence, more homelessness, more incarceration of our mothers, and more incarceration and removal of our children. There is more destruction of our cultural heritage every year. There's more loss of our lands, and there's more pollution of our waters. These are the things that are the fabric of life for us. The federal government's Closing the Gap program, I think, has been remarkable. It's been remarkable and remarkably successful, at least in measuring many of the failures. as far as I can tell, it has done little to change the trajectory of disadvantage. In almost every aspect, it has been a failure. There have been some successes, but just about in every aspect it has been a failure. And I must confess that I have had mixed feelings about that program since its inception. For it was really difficult for me to get over the whole idea that we might be aspiring to be equals to the rest of the population. I understand the program is directed towards ameliorating or removing the social determinants of disadvantage which plague our communities, but I still flinch at the assimilationist undertones of us aspiring to be like everybody else. It seems on reflection that we made great advances between the 1970s and the 1990s, but that we stalled in the last 20 years, or actually went backwards in recent times. So I think there is a need for another period of disruption. The coming referendum might prove to deliver that for us yet. I know that Mullenjaiwakka saw some hope in the Uluru Statement from the Heart because we talked about it. We talked about the potential also for the voice to be undermined. We talked about our preference as lawyers for recognition of rights in the Constitution. We talked about how that had been rejected by the former Prime Minister, Tony Abbott. We never got the chance to talk about this coming referendum question for the voice because he had passed, but I tend to think that he would have been in favour of the referendum. I don't propose to call on his ghost as being a supporter of this referendum, but knowing the man, I think he would have been in favour of it because he understood that we need to keep moving forward and keep trying to make space for those behind us. For my own part, the voice is many things. In particular, for me, it's a necessary stepping stone to a national treaty process in which there's a national treaty framework that ensures there is a minimum level of integrity and fairness in the process. A framework that limits the possibilities for the entry into treaties that reflect some of the political bastardry that the state and territory governments seem to be able to draw on cyclically. And I say this not in any way pointing the finger at any particular side of the political spectrum. They both do it. I will add that it seems to me that truly just arrangements between our First Nations and the governments and the broader population of this country prove to be elusive because there is no underlying belief system which withstands the pressure of the other interests. By that I mean I have trouble seeing a real deep understanding of the need for a just country. And because that doesn't exist, it's too easy for us to be relegated to the sides. We are placated from time to time with grand gestures and performative acts and then forgotten about. So how do we respond to such inconsistency of engagement and policy? Well, in my view, we do need a national First Nations body. We also need state-based bodies, I think, but we do need a national body that can advocate fiercely on our behalf. These things are not handed over easily. We have to fight for them. And I think that if we enter First Nations to government agreements or treaties that seek to provide us with some certainties around our safety and existence on our homelands, then that will lead to better outcomes for us. They need to be treaties or agreements that are enforceable. This national framework, I don't believe, can be achieved without a national representative body. And in my view, the voice is essential for many reasons, but also that reason. Returning to our friend Mullenjaiwakka, I talked at the beginning about his being a man of principle. I just want to tell you, a dozen years ago, another friend of mine had received an Order of Australia award, and it prompted me to think about some additional recognition for Mullenjaiwakka. I rang Philippa and I asked her, do you think you would accept an Order of Australia award? She said, yeah, I think so. Don't know, but I think so. So on the basis of that soft yes, I organised the nomination and arranged a reference from his good friend and fellow Wallaby, Gary Ella, another one from one of his old colleagues in Chambers. I thought it was a very good application. About 18 months passed, and I contacted Philip and I said, have you ever heard anything about that nomination? She said, no, I'll ask Dad. And she did. And the short version of it is that he was offered the award, but he rejected it. He didn't tell anybody about it, but he was offered it and he rejected it. And when that was out in the open, I talked to him about his refusal to receive the award, and he said to me, look, I would have felt like a fraud taking that award. I spend my life fighting against the government and asserting my rights as an Aboriginal man. And I would have felt like a fraud, and I couldn't accept it from the Queen's representative. He didn't need to say anything more, but he did say then that, anyway, Oodgeroo Noonuccal returned hers, and he said, I'm going to stand in solidarity with her. If Philippa hadn't have asked, though, I don't think he would have told anybody. Nobody would have known. Tonight I've hoped to give a more rounded view of Mullenjaiwakka, as well as sprinkling a few political messages. Mullenjaiwakka and I, and most people he had association with, had serious moments where we discussed the most serious of things. Discussing many more issues than I've raised here tonight. But I've got to say, mostly we laughed and joked and had fun. It wasn't all serious discussion. As he said of himself many times, and Philippa told us tonight, he said all he needed was an opportunity, and he made the most of that. For many of us who are following in his footsteps, we might have needed more than the one opportunity. I know I did. But we do get there with the right support. The Mullenjaiwakka Trust, named after the great man himself, seeks to ensure that, at the very least, lack of financial resources does not hinder opportunity for those wanting to be practicing lawyers or barristers. And I can only commend it to all of you as a means of assisting the development of the justice system that we would all like to see. Thank you.
Thank you, everybody. My name's Kristen Hodge. I'm the president of the Indigenous Lawyers Association, and I'm just going to do a couple of thank yous and then I'll let you get to the food. So first and foremost, I want to thank Uncle Chet for his beautiful, warm opening and welcome. Thank you. And our sincere thanks to our esteemed guest speaker, Tony McAvoy SC. Your presence here tonight has been an immense honour, and your insightful oration has inspired us all. Your unwavering commitment to justice and the tireless efforts in promoting the rights of Indigenous people have left an indelible mark on the legal profession. We are deeply grateful for your valuable contribution to this event. To Philippa McDermott, we are deeply indebted to Philippa as the daughter of the late Mullenjaiwakka Lloyd McDermott for allowing us to honour her father's legacy through this oration. It's a privilege to pay tribute to Mullenjaiwakka's groundbreaking achievements as Australia's first Indigenous barrister and his remarkable contributions to the legal community. We recognise and appreciate the significance of yours and your family's consent in naming the oration, and we thank you from the bottom of our hearts. I have a couple of gifts, but in the interest of time, we'll do it outside. Chief Justice has already left us, but I just wanted to say that it's a heartfelt appreciation goes to Her Honourable Helen Bowskill, Chief Justice of Queensland, for graciously hosting the event in the Banco Court. Your unwavering support for Aboriginal rights, Aboriginal and Torres Strait Islander rights, and dedication to ensuring access to justice for all Queenslanders is commendable, and her presence tonight was a testament to the importance of this occasion, and we're really, truly grateful. I want to thank our event sponsors. We extend our generous sponsors who have made this oration possible. Our gold sponsors, Landon and Rogers, QUT Law, Kingwood and Mallison, Queensland Law Society, and Escott Media. Your commitment to promoting diversity and inclusion in the legal profession is laudable, and we deeply appreciate your contribution to the event. Our gratitude also goes to our bronze sponsors, McCullough Robinson, Norton Rose Fulbrad, Barry Nelson, Ashurst, Minter Ellison, Wilberforce Chambers, Parallax Legal, and HBA Legal. Your support has been instrumental to ensuring the success of the oration, and we thank you for standing with us in our pursuit of a more just and equitable society. Lastly, and certainly not least, I express our gratitude to each and every one of you here today. Your participation in this oration reflects a collective commitment to advancing Indigenous rights and fostering meaningful dialogue and striving for positive change. Your presence is a testament to the power of unity. We are honoured to have you in this endeavour. In closing, let us carry forward in the spirit of this oration, one of inclusivity, recognition, empowerment. Together we can build a future where justice knows no bounds and where the legacy of Mullenjaiwakka lives on in our hearts and minds for those dedicated to the pursuit of justice for all. The Honourable Lincoln Crowley said it best, in the end, justice is what it's all about, always was, always will be. Thank you.